Morning, docket number SJC-13575, Commonwealth versus Michael Moscaritolo.
Okay, Attorney DeJunius.
Good morning, Your Honor. Good morning, members of the court. My name is Patty DeJunius. I represent Michael Moscaritolo in this case. Today, we're asking that you reverse all of his convictions, but at least the one on murder, with a directive to instruct the jury on manslaughter. This is a very unusual and sort of bizarre set of facts involving a tragic death that never should have happened. But the important thing is to keep our eyes on what Mr. Moscaritolo did as opposed to the result of this gruesome death. In Commonwealth versus O'Brien, the court addressed manslaughter instruction. In that particular case, Mr. Moscaritolo, however, had a separate trial, and the facts suggest that he played a different role than the other two joint venturers, in that he was the mastermind. He had been interested in stealing the belongings of the victim for nearly a year at that point. He had chosen two people because one person was going to steal, the other two were going to look out for the victim, since Mr. Moscaritolo is the quote-unquote mastermind whose interest in these items had lasted for so long. I think it's reasonable that a juror could at least infer that he was the one who was doing the stealing while the other two were in the main part of the house. So the marijuana was in the basement. The guns were in like an attic space that was accessible only through the garage. The violence happened in the two bedrooms and the hallway.
Given the quantum of violence, how is this not like O'Brien in that it's at least at a minimum third-pronged malice?
Because the jury could reasonably conclude that Mr. Moscaritolo had a different role than the other two. So one person was doing the stealing, two are the lookout. The Commonwealth's theory is that all three were beating and chasing at the same time. That doesn't really make sense given the layout of the house, the small nature of the rooms. But where the items that were being stolen were located, somebody was not where the violence occurred. I think that's a juror could at least infer that.
How is that possible when there are three types of footprints in both the bedroom, the main bedroom, and the spare bedroom?
So in the spare bedroom, there's only bloody footprints of the victim. The shoe prints are in the master bedroom. But we don't know when those were made. It could have been after the fact.
Regardless, they contradict the idea that all he's doing is going to the attic and going to the basement.
Well, let me be more concise. At the time that the violence occurred, I mean, there are three sets of bloody shoe prints, so all three of them were in the part of the house where the bleeding was happening, where the violence occurred. But a juror could conclude that Mr. Moscaritolo came to that location after the violence had already been inflicted upon the victim.
So at that, can you give me an understanding of just the victims? I'm going to call it flight path, but you don't have to call it flight if you don't want to adjust, but path, because he ends up in the kitchen. He goes to the garage at some point. I take it that the conflict begins in the hallway and then goes to the bedrooms and then goes to the garage. He then goes to the garage. I'm just asking about the victim's path. Can you tell me what the evidence showed on that front?
Well, it's not very clear what the path is because we don't know what happened first. But I think it's fair to say...
But it is fair to say he ends up in the kitchen.
Yes, absolutely.
Okay. Then the fact that that their footprints, which could be inferred to be the defendants, end up in the bedrooms would mean that they end up there before the victim ends up in the kitchen.
Well, I don't necessarily...
Because they're in blood. Well, unless there's any evidence that shows that he went back into the bedroom after he was in the kitchen, I think, with all due respect, you might have to agree with that.
So, Your Honor, he was struck with the frying pan in the master bedroom. We know that because the frying pan had drips of blood on it and no blood underneath. So I think it's fair to say that at least the beating with the frying pan happened in the master bedroom. From there, the victim, but not the joint venturers, went into the spare bedroom. And I say not the joint venturers because there's no bloody shoe prints in there. There's only bloody footprints. I think, so from the master bedroom to the spare bedroom, and then, down the hallway into the living and kitchen area, I don't believe that the victim went into the garage. I don't think there's any evidence of that. I know there was some blood that had dripped down into the basement area, and I think there was a bloody shoe print in the garage, but not that the victim had been there.
Would you agree that this is a robbery, a botched robbery that went bad?
Yes.
All right, then why do we care who the mastermind is when he's there? That whatever plan he had was botched and led to 2 hours of an incredibly violent confrontation with the victim.
There was evidence that the neighbors heard something at 1 a.m. and something at 3 a.m. I don't believe it was the Commonwealth's theory of the case that they were inside for those solid 2 hours. The only evidence that would even remotely suggest that is the fact that there were noises heard at 2 different times.
Well, and also that all the marijuana plants were taken.
They were not taken, Your Honor. They had already been harvested by the victim, and they were stored, I think, in the closet, and there was some in the oven. I want to get back to what you had asked. Why would the bloody shoe prints be in the master bedroom? Well, the evidence shows that they were rummaging around through the drawers in the closet in that room.
Right. So after the victim had already been attacked.
Yes, it's.
So that undercuts the theory that one of those participants is just mastermind beforehand, right?
Well, I would suggest that a jury could infer that the 3 of them ended up in that bedroom, the third person after the violence was inflicted, because they were there to steal. I mean, I'm not saying that my client engaged in any appropriate behavior. It's sort of disgusting to then go, after this happens, to then go and steal from him. But the evidence does support that theory.
So there's a theory that they continued the robbery after they had inflicted the damage on the victim.
Yes, Your Honor, and that would be supported by the blood smeared on the drawers and the closet. So I think, is it compelling? Maybe not.
How does that get you a manslaughter instruction?
Well, I don't think that necessarily gets me a manslaughter instruction, but what I'm doing is explaining.
Doesn't it foreclose a manslaughter instruction?
No, I don't believe that it does. Not when there's no evidence of when footprints were put down. I think they were stealing from the master bedroom. I don't know if they actually got anything, but they were in there. It's certainly conceivable that the person who planned it, who wanted those guns and wanted that marijuana for himself, went into that bedroom after the fact. It might not be compelling, but this is manslaughter. You have to look at the evidence. Is there any view of the evidence that a juror could come back and say manslaughter? And so could a juror reasonably find that Mr. Moscaritolo had a different role that took him away from the violence? He was wanton and reckless in planning this the way that it happened, to go in the middle of the night into somebody's home who has lots of weapons, with your criminal defense client and his friend to watch out for the victim.
Can I ask you, was this a theory that was argued to the jury? Or is there any evidence in the record that would support this theory? So you're saying, no, it wasn't argued.
It was not argued because defense counsel knew before the first trial started that a manslaughter instruction would not be given. And so knowing going into trial that you're not getting a manslaughter instruction, you're not going to try the case as it's a manslaughter case.
Did you request a manslaughter instruction?
Yes. Yes, before both trials.
And was that theory that you're presenting on appeal, was that presented to the trial judge?
Not specifically. I think that the focus was at that point more on the manner of death, and that the victim had gone through the window, and that the jury could infer that that was, as a means of escape from the crime as it was occurring, and that would support a manslaughter. But no, this
address then the Commonwealth's argument in response to your new theory. That the case law supports the proposition that the trial judge need not engage in speculation as to what theory the manslaughter might be supported by.
I don't recall the Commonwealth making that argument, but I think that there was enough that was argued to the court, especially with the sort of bizarre set of injuries that do factor into what I'm saying, which is that the violence, the intentional violence on the victim would have been in the master bedroom. And if that is—
What do we do with the purple latex glove that's found near the master bedroom that has your client's DNA?
Well, I think that it shows that he was there, but again, without evidence of the sequencing of events, what happened?
Where was the glove?
I think it was the kitchen area, like kitchen living area around there. It wasn't in one of the bedrooms.
Okay, thank you.
But it's in the area where he ultimately is found, right?
Not far from the body, correct?
Okay, so if his glove was not far from the body, and you're saying he's just the mastermind who takes a passive role, why is his glove next to the body or near the body?
Well, I'm not denying that there's evidence that my client was in that part of the house, right? But could a juror find that he wasn't in that part of the house when he was hit on the head with the pan?
Let me ask you, on the premeditation part of your brief, why do we reach that where the jury came back with felony murder and atrocity or cruelty?
I think you reach that if there's going to be a remand for manslaughter instruction, that would limit the theories that the Commonwealth would have available.
Okay, so if we disagree with you on the lesser included of manslaughter, the evidence is sufficient because you don't argue otherwise of murder one based on the other two theories.
Correct, Your Honor.
Okay. Correct. And then your hearsay argument, I thought was quite well argued. Why is it prejudicial error, assuming I agree with you?
So because this was the only evidence that my client actually planned it, that he was the mastermind, which resulted in quite a hefty sentence on the non-murder counts. I think he was 30 to 40 years, in part because he was the mastermind. But that's the only evidence that he was involved in the planning. Tom Gunning actually told the police that he had no reason to believe that Mr. Moscaritolo had planned it. He certainly was interested in it, but we know that Mr. Ferguson was one of Mr. Moscaritolo's clients. And so I think that, it could be inferred that, strike that, I apologize. This evidence that came in through Ms. Romani was the strongest evidence of Mr. Moscaritolo's involvement during the commission of the crime. I think that the theory that had been argued to the jury was that Mr. Moscaritolo might have gotten a phone call from Mr. Ferguson and then gone to the scene after the fact. Whether this court's convinced with that theory or not, the fact of the matter is that there was a hung jury after the first trial on the murder count. So it's without that evidence, I think the case that Mr. Moscaritolo was planning it was much, much weaker than with the evidence.
But wasn't that, that was helpful to your client, that evidence, because it helped to distinguish, wasn't an important part of the defense, the hearsay within hearsay statement that your client didn't, no one was going to get hurt. And so can you explain to me how this has any prejudicial effect when the substance of what came in was actually buttressing the defense of your client?
Well, somewhat, but not entirely. The evidence came in.
What part didn't?
What part didn't? That he was planning it, that he chose 3 people to participate in it, and the evidence showed that 3 people did in fact participate in it. So the evidence comes in, you do what you can with it. But if it had never come in the first place, then
there would have just been the forensic evidence actually attaching him as a full participant in the crime itself.
So the theory of the defense was at both trials was that Mr. Moscaritolo might have been called to the scene by Mr. Ferguson, and that's why his DNA was present. And again, the jury was hung after the first trial, so I think it's fair to say that was at least somewhat persuasive to them.
What about his girlfriend's testimony on prejudice?
So his girlfriend's testimony only came in during the second trial.
We'll talk about the second trial.
Yeah, so that's, okay, that's true. So she had admitted lying to the police numerous times. I don't think that she was a very credible witness. There was certainly more than enough evidence to challenge her credibility that I think that whatever testimony she gave was not strong enough to overcome the prejudice.
All right, so we have the girlfriend's testimony that of mastermind and his plan. I know your argument is she was impeached, but then we have Gunnan's testimony, and I know he disclaims it, but he also says that the defendant is the one who is interested in all the photographs, etc., all the pre-planning, right?
So he also testified, though, that he sent photos of both the marijuana and the firearms to numerous people, and that Mr. Moscaritolo was not the only person who expressed interest in the marijuana and the guns.
Right. And then we have his DNA on a latex glove on the dining room floor.
Again, and the theory of the defense was that was placed there afterwards, and the jury was hung after the first trial. So I think that, we can't just automatically dismiss that. Whether, it would convince me or you is not really all that important here. The fact of the matter is that it did seem awfully important to the jury. If there are no other questions, I would rely on my brief for the remainder of the arguments.
Great, thank you.
Thank you.
Attorney Johnson.
May it please the court, my name is Melissa Johnson. I'm an assistant district attorney in Plymouth County on behalf of the Commonwealth. Starting with the hearsay argument, which is where we ended, Your Honor, actually, this is not hearsay at all. This is the
At one level it is, and one level it isn't, right? So I read Wilkerson. I think this is entirely different than Wilkerson because the furtherance argument can be established by solicitation, right? And we have that. But in Wilkerson, there was one conversation. Here, the problem the government has is there's a second conversation that's relayed. You have to satisfy hearsay exceptions for both.
Well, if I could just clarify, it's actually not hearsay. It's a statement of a party opponent because it's originally the defendant's statement. That's an exemption to the hearsay rule. And then it's a statement by a co-venturer, from a co-venturer to a co-venturer.
And then it's relayed.
Right, exactly.
The relay
So
part is the problem.
It's two exemptions to the hearsay rule, so it's not hearsay at all. But the third level, as you're talking about, to Romani, who is the defendant's girlfriend, I would argue it is exactly like Wilkerson, and it's like Rakes, and it's like the footnote that Bright had talked about, this trusted associate, this trusted audience. That's what's giving it the indicia of reliability that qualifies it for the hearsay exemption. When a co-venturer is making a statement to a recipient that he or she trusts, that is loyal, that is a sympathetic ear, they're giving that recipient that information with the understanding that someday when the police come knocking and start asking about this particular crime, that person is within the circle of trust that is not going to reveal that information. That is exactly what happened in Wilkerson. And in fact, that's exactly what happened here. Romani lied to the police when they confronted her. And then she actually didn't even show up for the first trial. We had to issue a capias. We had to issue her a grant of immunity. So that's exactly the same situation. And I can give other examples where this person doesn't have to be involved in the actual plotting and execution of the joint venture, but they do have to be within that circle of trust. It could be a family member, a close friend, a girlfriend, a spouse. There are examples I could give from Stedman, from Wood, from the Winquist case. All of those cases give examples where that person, while not involved in the plotting and execution of the crime, were actually within the circle of trust such that the declarant who gave that person that information trusted them to have their back when the police came knocking. And that is what's giving the indicia of reliability to that statement, Your Honor.
What about assuming I disagree with you, why is it prejudicial? Why isn't it prejudicial?
Well, I hope you don't disagree with me, but it's certainly not prejudicial given the volume of evidence that the defendant was involved in this. So we can talk about the physical evidence, the defendant's DNA on the glove that was in the dining room, and also in the wearer DNA and the shoe print of the shoe that was in the bedroom where this attack took place with the frying pan. So we have the DNA evidence. We also have this DNA evidence around the perimeter of the house as well on a glove. We also have the CSLI evidence, the cell phone location information evidence that placed the defendant at the scene at that time. So we have that information that he's actually there. And then, of course, we have all of the testimony from Gunning and Savoli, who basically corroborated the fact that the defendant was very, very interested in this victim and his victim's possessions, his drugs, his guns, and was almost fixated on this. He wanted to know from Gunning what the layout of the house was, where all the doors were, all of that information. So while Romani's testimony was certainly helpful, it was not necessary, and if we didn't have it, we still would have obtained a conviction in this case. Are there any further questions about Romani's testimony?
Just one.
Yes, Your Honor.
Going back to the issue of whether or not this is non-hearsay or not, the factors that you lay out, can you use the factors that you stated here in court, the after-the-fact factors, in assessing whether or not she was in this kind of circle of confidence?
If you're asking me, does the crime have to be over at the time, or is that what?
Well, you laid out two things in particular. You said the things about how she lied after the fact, and I can see that point. But you also listed as a factor that she wasn't cooperative with the prosecution, and that you needed to get a capias for her. Yes. Does the trial judge get to consider that?
I think it's part of the equation, Your Honor. I think it's a very fact-intensive inquiry whether this person is sufficiently part of the so-called conspiracy. Again, they don't have to be an important or necessary part. I think it's going to be a fact-intensive inquiry, and that's why this judge gave a voir dire of Romani to kind of assess. Well, of course, the main point of it was trying to authenticate that it was actually the defendant that called Ferguson. But part of it was to assess what is her role at the time that the statement was made to her, to try to assess the indicia of reliability. So he was really looking at the time that Romani had made this, the time that Ferguson had made that, relaying what the defendant had said to him to her. And in fact, you can tell that the defendant was truly exercising his discretion because he didn't admit a statement that Ferguson had made after the fact to Romani. There was a conversation between Romani and Ferguson where Romani was like, "You said nothing bad was going to happen." I'm paraphrasing. And he said, "Well, I don't want to talk about that," and got emotional. And Judge Moriarty didn't let in that statement. So he was truly assessing at what point does this become a part of the furtherance of the conspiracy. Does that answer your question?
It does. It does. Thank you.
Okay.
So I take it you're not relying on any specific exception to the hearsay rule. You're making an argument that as long as the information is reliable, the judge could admit it?
Your Honor, respectfully, not quite. I think what I'm saying, and I wish I could remember the case because I was reading it last night, where it distinguishes between an exception to the hearsay rule and an exemption to the hearsay rule where it's not hearsay at all. I was just trying to explain the layers here. The first layer being that it's the defendant's statement originally. So it's a statement of party opponent, yes, not hearsay, conveyed to a co-venturer. I think we can all agree that Ferguson was a co-venturer, so that's not hearsay. The co-venturer is not an exception. It's actually an exemption to the hearsay rule. And then conveyed to another co-venturer Romani, granted, as I just explained, she's not involved in the plotting and planning, but she's a trusted audience.
She's the only one who testifies to this.
Yes.
So that's the problem, it seems to me, correct?
Well, that's always going to be the challenge with
Right.
a
So
co-venture.
and so your theory as to why she is permitted to testify to that is some sort of test of reliability?
Yes, Your Honor.
All right. So we have I was just looking at the guide to evidence, which makes clear that we do not have a residual exception to our hearsay rule, right? And it feels to me that's sort of what you're trying to say.
That's not what I'm trying to say, respectfully, Your Honor. I'm just trying to say this is another co-venturer, part of the co-venturer exemption. So it's from the original defendant to a co-venturer to another co-venturer. So kind of like the Wilkerson case, although that case was a co-venturer to the defendant to another co-venturer who was the girlfriend. So there could be many co-venturers. I don't think that there's a limit to how that exemption can reach out to, as long as the judge can find that at the time that the statement is made through voir dire, or however he wants to make that determination, or she wants to make that determination, that there is that indicia of reliability, that these people are within the circle of trust.
What's your best case for the circle of trust? We're talking about Romani, who's not a co-venturer, but someone on the periphery of the relationships.
I think there's a good discussion in Rakes, which I cited in my brief at 478 Mass 22. I do have a couple of examples that I didn't cite in my brief, if I may, though.
All right, so Rakes is the case I should look at?
Yes, Rakes has a good discussion of that, but I also would look at the footnote 21 in Bright, is what really, where I really feel like this court really talked about the third party and how we can consider whether they fall within the co-venturer exception or not. Of course, we know that some kind of unaffiliated or unrelated third party, that's not going to qualify. However, where you have a situation where that third party is actually within that circle of trust, where they are a trusted recipient, a sympathetic ear, a loyal person who's going to have that declarant's back, then that may qualify. So that's the footnote 21 in Bright. But there's also the Stedman case, which is at 489 Mass 372, where it was a family member. Again, not someone who was intimately involved in the actual planning and plotting and all of that. There's also the Wood case, which is at 469 Mass 266. And that was a girlfriend, similar situation to this. There's also the Winquist case, which is at 474 Mass 517. And that was a friend, a loyal friend. If there are any further questions about that particular issue, I'd like to move on to the involuntary manslaughter instruction, which my sister had brought up. Your Honor, I'm not sure I could say it any better than how it was said in O'Brien, given the fact that the facts of this case simply do not support anything other than a finding of malice, even looking at it in the most generous light to the defendant, as we must in this case versus O'Brien, which is a slightly different.
Can you address directly, though, the theory that the defendant was the one looking for the marijuana grow operation and the firearm collection, which were outside of the main house, and that the other two co-venturers were the ones inflicting the beating and causing the death?
Well, Your Honor, I understand that that was his original plan, but the physical evidence simply does not support that at all. It is pure conjecture, because we have the defendant's DNA on a glove that's in the dining room that is near the bedroom. We also have the defendant's wearer DNA on a shoe print that is within the bedroom. We know that the main attack with at least four whacks to the head with a frying pan occurred in that bedroom. And then, of course, we have all three footprints around the victim's bare footprints, or I should say, the three shoe prints are around the victim's bare footprints as the victim is essentially sliding through his own blood, trying to make his way to the kitchen where the alarm pad is. So we know that all three of these co-venturers are in the house. There's no way that they are not aware of what is going on at all times here. And if my words in my brief have not conveyed it enough, I urge this court to look at the photos to see where the blood was, where the shoe prints were, because they are throughout the house. And in fact, Your Honor, you had noted in the O'Brien case, and O'Brien was arguably the least culpable, although they all have culpability. In that case, it was noted that there were three sets of co-venturer shoe prints alongside the impressions of the victim's bare feet throughout the victim's home. This fails to support a theory that the defendant, and that was in that case O'Brien, was merely present inside the home and was unaware of and not complicit with the repeated and brutal assaults on the victim as he moved from room to room around the house, spurting blood from his extensive wounds. I don't think I could be any more articulate than this court was in O'Brien, that was the case. All three of these co-venturers fully knew what was going on at the time, despite their original plan to simply rob the victim. If there are any further questions about that, I noticed that my sister did not reach the other arguments. I'm happy to answer questions about those if the court should have them. If not, I will rest on my brief, ask that you affirm the conviction for murder in the first degree.